Hello, I'm Kelly Tait. I teach in the Speech Communication Department at the University of Nevada, Reno, where I teach things like intercultural communication. In addition, I do a lot of judicial branch education. And in that, we've been looking at how special populations, people's membership in different groups, affects their perceptions of procedural fairness. And we're going to be looking at that today. What can you do to ensure that people of all different groups do see the process as fair and therefore comply with orders? So the learning objectives today, we are hoping that at the end of this, you'll be able to recognize that members of different populations bring different experiences and expectations with them to court. Of course, you do the same. This is on both sides of the bench. You're also going to be able to discuss the challenges that some of these special populations may present and identify techniques that will aid in promoting procedural fairness among these special populations, the ones that you see in court in particular. We'd like to start with really talking about cultural awareness. And I do want to say that when we're saying culture here, we're speaking in a lot bigger terms than a lot of people understand. It's really any kind of a group membership that affects the way people think and perceive and act. And so there's a lot of different groups that we're all part of. Cultural awareness would really be understanding and appreciating cultural differences and similarities within, among, and between groups. So that awareness of them will help you then respond in a way that will make it more likely that they will be seeing this process as fair. We're really looking at identifying, for you to identify members of special populations so that you can do that, so that you can be saying, how do I make sure that these groups who sometimes are left on the fringes are part of the process in a meaningful way? To start, though, we really need to look at how the human brain is built. It's one of those things that as part of your job to be fair and trying to not prejudge and not just act on stereotypes, you still have to understand that the way the human brain is built, we automatically categorize. It's one of the ways our brains can move quickly and make sense of the world very quickly. We have lots of information coming in. We're kind of flooded with information. So the brain is really trying to make sense of it by jumping to most likely solutions. So we kind of take some shortcuts and make quite a few assumptions under the level of awareness, without even realizing it. We're making some assumptions and treating people as members of groups rather than individuals sometimes. We do want you to remember that there's always major individual differences. It can be helpful to look at group membership and to be considering how that might impact someone in the court setting. But do remember the individual differences are there as well. So really what we're doing, we're kind of imposing a pattern on the world, trying to figure it out by organizing what we're seeing into conceptual categories. And often we're just doing this in a way that, how does what I'm seeing or hearing or doing now relate to what I already know? So these categories that have been put in place very early in our lives by our caregivers, by our friends, by the media, all sorts of different things, we're actually acting on those many times without even realizing it because our brains are categorizing so quickly. It is a good thing in some ways. It does simplify a very complex world and allow us to respond in often appropriate ways. But the most likely solutions and the assumptions that we make are not always the case. Most likely doesn't mean always. And so we have to remember that we're really, in a way, oversimplifying this very complicated world. So we do need some of the categorization, but it can also undermine our intent to treat everyone fairly and as individuals. This, of course, leads into to your responsibility in your job. It's part of your job to be trying to treat people fairly. It's also part of your job to make sure that they perceive that it's fair treatment. And so that's what we want to focus on. We need both of those things. We want a fair process and a perception that it's a fair process. And that's why we also look at the ABA Model Code of Judicial Conduct, which relates to a whole bunch of the different groups we're going to be talking about today. So when we're talking about enhancing procedural fairness, and of course the goals being both improving the actual fairness and improving the perceived fairness of the court system, we want to make sure it's really clear that, that interpersonal treatment is vital in this aspect, and with all groups, with everyone, but also especially with these special populations. Interpersonal treatment, of course, that's communication, the different communication factors, both verbal and nonverbal. We really do want this to apply to everyone in the courtroom, and it might take a little extra effort for people who are members of groups where it's even more difficult and even more of a challenge for them. Everyone does not come to court with the same set of expectations, and they don't experience it in the same way. And because of that, we really do want you looking at what might be the potential issues for some of these special populations in terms of promoting procedural fairness and those 4 key components. In addition, when we're looking at those cultural pattern variations and the differences in terms of perceptions of time, how direct or indirect communication is, you can clearly see that some of those things will be tying right into the legal system and some of the differences in the legal system and even everyday conversation. For instance, the very direct communication that's required in the legal system, the use of language. We have, it's challenging for any group, but even more challenging for some groups when the language that's used is formal. We have all kinds of special challenges with language, including strings of infinitives, heavy use of the passive voice, very complex grammatical structures, things like that that add an additional layer of challenge to the experience. So in addition to this, the formality, informality, one of the big ones in terms of cultural pattern variations is the attitudes toward authority. And there are some pretty major differences in terms of how likely they think the system is to be fair if they came from a system, if this isn't their country they were born in. They may not realize that the system is built for fairness and may come in with assumptions based on that. They may just assume they're not going to get a fair break, for instance, too. So there's a whole bunch of things that we want you taking into account, these things that are general variations across different cultures, in addition to then some of the specific groups we're going to look at. So these different groups, there's many, and we're not going to try to necessarily identify every single one, but we do want to focus in on some in particular and at least point out the other ones so that you will be aware of them and be looking for those potential issues and ways that you can increase perceptions of procedural fairness for all of these groups. So in addition to age-related and members of a minority ethnic group, limited English proficiency, disabled, mentally ill, self-represented, obviously some other ones that could come into play, religious organizations they're part of, possibly sexual orientation issues, literacy issues, and also socioeconomic issues. And that's actually a big one. Some of these obviously cross, so socioeconomic differences can have a pretty big impact across a whole bunch of different groups. And there's a fair amount of research that we will be pointing you to later if you want to look into that more. The group we want to look at in particular now that's to kind of focus in on a couple of these different ones. The first one is those minority ethnic groups there's quite a bit of research out there that these groups tend to have a lower expectation that they're going to be treated fairly. And so the research that's been done has certainly pointed out that African Americans in particular feel they will not be treated fairly, so they're coming into court with that expectation to start with. In addition, it's not just that group, but all major ethnic groups actually do also say they do not think it's as likely that members of African American groups, lower income groups, and limited English proficiency groups are as likely to get a positive, fair outcome and to see the process as fair. So everyone, not just the members of that group, but also members of the general population see that there can be an issue here. With some of these ethnic differences, there are some particular things that you can do. As we said, we tend to categorize when you're in a hurry in particular. We often rely on those categories without realizing it, so we treat people as members of the category as opposed to really looking at the individual cases. Some of the things you can do to slow down the process a little bit so that we're not making the leaps and we're really using the higher levels of processing in our brains are to do things like to reframe it, maybe reverse the parties. If this person were a member of a different group, would you respond differently? Would you do the same thing if they were a different one? Another technique is to think of counter-typical examples. So if our stereotype, and we all come with them, they're kind of built into the general culture. If someone, we don't want to respond to them as if they're just the stereotype. Think of someone who doesn't fit that stereotype, who's a positive example in your mind, and that can sometimes help you remember to treat someone as an individual, and to also remember that every group has people who cross a wide range. Limited English proficiency is another area that we think is pretty important to look at. This is one of the groups that also we tend to think is not going to get as fair a shake, will not think they are, that other people perceive that. And so looking at who is in your court, who is there, what groups tend to be represented. Again, we don't want you to rely just on the groups. It's really important to be thinking of them as individuals, but there can be some group tendencies, and certainly with language, understanding what languages are likely to show up in your court. And we have examples, obviously, from Milwaukee. In addition, you really need to just be saying, what is important in my court? I've talked to judges who have so many languages, there's no possibility they could list all of them or really kind of take into account each one of them. So some of those general practices we've talked about that are good to use with really almost anybody, but in particular with people who have these special challenges, will be good to cross over all different groups. So some of those things, trying to ease the process of requesting an interpreter if one is needed, right? Signage, instructions, things like that. Trying to mask any frustration you might have, any impatience with the extra time that interpretation might take. And even if there isn't interpretation, if you don't have an interpreter, it's still going to take more time. You still need to slow things down a little bit. And to make sure that you're speaking clearly, not necessarily more loudly, but clearly and a little more slowly. And that makes it more likely that somebody's going to be able to understand what you're saying based on the language, even if they're somewhat limited. Obviously, the other nonverbal cues you want to take into account: eye contact, body language, tone. On this one, obviously, we're going to be saying across different groups, there are some major differences in how much eye contact is considered appropriate. And so we don't want you making assumptions that are negative because you're not getting as much eye contact as is common in the general overall U.S. culture. So body language, though, can help all those things we talked about, orienting your body toward the person you're talking to and listening to. Having some eye contact, and as the authority figure, it is a good thing to have some eye contact, but not to negatively evaluate it if you don't get as much back. Really paying attention to your tone of voice. That's where so much respect comes through. So all those different things. And we do want to say, remember that even though as the judge, you are a huge part in these perceptions of procedural fairness, but you should be paying attention all the way through the court experience to what's happening and how people are being treated. And a lot of what you can be looking at is these things in addition, the tips we're giving you for court staff and others as well. So there may be certain questions you can ask, dialogue you can start to make sure they do have the level of understanding needed. It's pretty important to think any of these groups, many groups, even the general U.S. culture, will have the default answer of yes when they're asked if they understand. They feel like that's the expectation. And certainly if it's a culture that has some different attitudes towards authority figures, they may just assume you do not question them, so you would automatically answer yes. In addition, someone who says yes might just mean that they understand what you said or that they heard you, not that they agree. And so you need to make sure that where this understanding is particularly important, you do open it up to that two-way communication, questions, dialogue, that will help both you and them increase understanding. The colloquial jargon, hugely different, right? There's a bunch of things that you have to be careful of, acronyms, colloquialisms, all the different things that may not translate across cultures to people who have a different first language. And really educating yourself. We're looking at what are some of those cultural norms, even if you don't know for each individual group, it's good to know that there's a big range. There's a wide range of possible reasons for certain behaviors and for what people expect to be happening and what is considered appropriate. With self-represented litigants, a whole bunch of those best practices in verbal and nonverbal communication really apply with this group. I think the other groups as well, the other special populations, but things like giving that mental map, that early explanation of how the procedures operate here, how it's going to run, what the ground rules are, some basic ground rules for behavior such as not interrupting. Doing those things early is a really good idea for a couple reasons. One is obviously they're more likely to follow them if they know what they are. Understanding, of course, you might have to say it more than once. But also when people understand what's happening, some sense of the procedure, they're much more likely to calm down a little bit. They feel like they have some control in it, even if they don't have a lot. The knowledge of how it works makes them feel a little bit calmer, and that's often a good thing with people who are representing themselves in court, and there's a lot of emotions going, and they're nervous in this very intimidating environment. So I strongly encourage that mental map ahead, letting them know when they're going to have the opportunity to speak. I think you should tell them that even though they can't interrupt, you might need to interrupt because there's a limited amount of time and we're trying to accomplish something here. If you've told them early that you might interrupt, it's much easier to then respectfully redirect them later, to kind of step in and turn the conversation toward what you do need, toward the information that you do need. And of course, the parameters of that information. It is an area where it's really important to be looking at those 4 factors, those 4 key components of procedural fairness. Did they feel they had a voice in the process? Did the decision maker really listen to them and take into account what they were saying? Did they understand what was happening? Right? That ties directly into doing that mental map, into letting them know how the procedures work, when they're going to have a chance to speak up. Also pausing long enough when you ask if they have something, giving them a real chance to actually process it and then speak up. Even more important with some of the different cultures as well, where the longer pause is necessary. It's respectful, and you need to anticipate that it might be longer than what feels normal to you. So a bunch of these different things, including paraphrasing, that's a power tool. Paraphrasing both on your side to let them know they've been heard, it shows you've been listening and that you understood it, but also to make sure they understood by having them put it into their own words. So using all those different tools we've talked about in terms of good practices for verbal and nonverbal communication help across these different groups, including people with mental illness. Of course, with mental illness, people with mental illness, patience is huge. And you are just going to have to anticipate that as a necessary thing. I think breaking things down into chunks, small steps, being very clear on what are absolutes, what consequences are, what certain dates are particularly important, things like that, deadlines, really important. But don't forget that repetition shouldn't be irritating you. It's one of the ways you're going to make sure that they are able to participate in this process as effectively as possible. With disabilities and populations who come to court with disabilities, of course not all of these are visible. We are talking about a wide range here, speech, hearing, other physical limitations. So it covers a pretty wide range and not always something that we know stepping into it. Clearly we want access for everyone here, and that includes physical access, which becomes particularly important here. In addition, I think you need to really examine what assumptions we tend to have when we see someone with a disability. I was in a very serious car accident, so I was in a wheelchair for 4 months after I got out of the hospital. And it was really interesting to see people's reactions to me and how differently they treated me, how differently they assumed my brain worked because my body wasn't fully functional. And when I talked to a judge once who had a similar issue where he had been a college athlete. He played football in college, and he said he had an injury that required crutches. So the first day they gave him crutches, and they were the kind that go under your arms, and they really hurt. If you haven't done them, they rub you, and it's a different kind of movement. So he decided to get a different kind of crutches, and he got the kind that actually seem more permanent because they're a little more comfortable. So they went on his arms. He said the difference in the crutches he used made a difference overnight in how people treated him and the assumptions they made. He went from being an injured athlete to being an invalid overnight based on that one thing. So understand how much of this, these little quick leaps we're making and assumptions we're making often are not correct. And we have to build in that pause, that moment where you really accept that there might be a real wide range here of possibilities for people's behavior and for the different abilities. I also think with disabilities, it's a good idea to be looking at some of the online resources as well. There's some pretty good technology available now for people who do have sight issues. And so make sure that you have it accessible at every level in terms of those forms available, the explanations of them, and actually the physical access to them as well. With in-custody defendants, I think that moment of really thinking, what was it like for them walking into the courtroom? What happened right before that? What was the chain of events that led up to it? And how were they treated by all of the people in the system from the beginning? Because procedural fairness moves throughout the system. And I have seen some people come into court in the jail garb with hands handcuffed behind their back. One gentleman I saw was clearly trying to be respectful, and he walked in blinking. He obviously had been someplace a lot darker. All of a sudden he's in this big room, everyone's looking at him, shuffling forward because of the handcuffs and the other restraints. And then his prison pants, pajama pants, were falling off, and he was trying desperately to pull up his pants with his hands handcuffed. And it was just, it was almost heartbreaking to see from behind, and I don't even know if the judge saw it, because he had to be looking down and had things he was doing, and understanding that could have a pretty big impact on that defendant's behavior in the next moment if they feel that lack of control and an inability to even respond what they would consider respectfully as well. So I think about that experience. What happened in advance? I know there's one judge who said the holding area in his courtroom, in his courthouse, is ill-equipped. They actually have to take people out to the sully port, kind of the garage part, and chain them to the ground out there in order to talk with their attorney. So they're sitting out in this kind of exposed area, chained to the ground, and unable to really have the time and the communication environment to be able to get that level of understanding that they need. It certainly doesn't seem like respectful treatment. That judge has made a change and is working with the sheriff's department in coming up with a different option. It's a cost-effective option. Everyone thinks it's important, and that treatment throughout the system is going to make a difference in the long run. The people you see in court frequently, those frequent flyers, really do come with their role being loaded by expectations and assumptions on both sides, theirs and others. I think for them you need to really keep in mind that you need to individuate each situation, each case, each person. And I've had some people say they saw it themselves even when they saw people from the same family. Oh, here's another one of the Johnson boys. And they actually heard themselves saying it to themselves and went, wait a minute, this is a different time, a different person, a different place. So that tendency to kind of, here we go again, same thing next day, you need to really work to make sure that doesn't happen. Your attitudes toward people from all different groups all throughout the day are kind of coming through your nonverbals whether you know it or not. So if you have that negative attitude because you see someone who is particularly challenging because of whatever group, whatever special population they're part of, that negative attitude is likely to come through, particularly through your nonverbal communication. The length of pause, do you turn toward them, lean toward them when you're listening? How much time do you give them? How long a pause do you have? What's your tone of voice? So all of those things are things we want you to take into account when considering the different special populations that come into your courtroom. This is a real opportunity for you to be thinking through what can you do to ensure they feel they have a voice in the process, that they're being treated in a neutral manner by the decision makers and the people in power, that they have an understanding of what's happening, and that they were treated with respect. Those 4 components of procedural fairness and perceptions of procedural fairness are critical across the board, and maybe even more so with people from these special populations. We do want you to take a moment to really think about what you're bringing here, what your background is, what assumptions you tend to make based on your individual experiences and the different groups you're part of, and the larger culture, of course, that you're part of, and the media that portrays that culture as well. So really think about what assumptions you might be making when you look at some of these particular situations. Evaluate it, maybe even write down what are the possibilities, what are the range of possibilities of different groups they might be part of, what's the range of possibilities of explanations for certain kinds of behavior. So take a moment to do that. What this really comes down to is putting that little bit of extra effort and time into making sure that these things that we know, that we have proof, make a difference in terms of people's perceptions of the system and of their treatment within the system, that make sure that's positive, that has the ring of truth to them, that they have been treated fairly within the system. So it takes a little bit of doing your homework. Learn about some of those special populations that do appear frequently in your court. Keeping in mind, there's always individual differences, that we can get general tendencies from knowing about the groups, but we don't want to make assumptions based on that either. So if you have special knowledge of a certain population, a certain group, you can use that information to help colleagues, court staff, help others work better with members of that population, anticipate the special needs and the issues that might arise in relationship to how they evaluate the fairness of the system. Make sure that you have information and provide it about the available resources that could assist some of these special populations, interpretive services, free assistance with some of the court issues. Maybe there's anything like that that you think might be helpful. Have that in mind, have it ready to go, have it in a format and with language that is very clear, easy to understand, accessible to everyone. We come back, of course, to our good practices and those things that cross over for special populations and others, but are particularly important with special populations. Speaking slowly and clearly, at least slowly enough that it's understandable, right? Not forcing the pace when understanding is at stake, whether it's because of language issues or that they're unfamiliar with the legal system, legal terminology, those kinds of things. Maintaining patience and calm when there are misunderstandings. There will be, we're human, things are going to come up. You need to have some kind of cues that help you maintain your patience, whether it's that the quotation on the bench. I've had some people say they just make sure that they take nice deep breaths every so often in between hearing different cases or when something in particular happens. That they can feel that they're responding to emotionally. We all do. Our emotional responses happen a lot of times more quickly than our intellectual responses. So being able to have something that allows you to respond in an appropriate manner with the calm and patience that you need. Being very aware of language, not using slang, jargon, legalese, the different shortcuts we tend to take. Even things, analogies that you might think are very helpful and that often can be, might not work with certain populations. For instance, if someone is from a different home culture and is not familiar with some of the U.S. sports, I've seen judges use a lot of sports analogies, for instance, baseball, which just doesn't resonate with somebody who isn't from a culture where that's one of the common sports. So being aware of that, making sure that you don't use something that is actually likely to be more confusing rather than less, when clearly that's not what you're trying to do. You need to be particularly careful about humor. Even though humor can be a bridge, there's so much potential for it to be misunderstood when you're crossing different cultural groups. So you need to be very careful of that and possibly just avoid it if there's a likelihood that it will not be received in the way that you're hoping. Obviously, we do not want to presume that everyone shares the same experiences and expectations. There are differences everywhere, and we have to understand that we're seeing the world through our own lenses as well as everybody else, and that's going to make a difference in terms of what they do in court, how they perceive it, and what happens afterwards. We want to have an impact all the way through the system and beyond, and really improve the justice system overall. You may need to repeat yourself. You need to really be careful to not have things like very long sentences. I think being very aware of some of those special things that we tend to do in the legal arena with the multiple negatives, the difficult grammatical structures, use of the passive voice, those kinds of things. Those are good practices to get rid of. They are not clear communication. And when we're saying effective communication is the goal, because that interpersonal treatment ties directly to perceptions of fairness, you need to remember that that comes directly into play with this one. Phrasing your questions concisely, all those different things, and having those reminders that help you do the best job you can. We know you have good intentions. You're busy. There are a lot of things that can come into conflict with what the overall goals are for yourself and for the system, but it's worth really paying some attention to these practices, these good practices, when you're working, when you have people from special populations in your court.
Sort of summary for this section and this understanding of special populations. You need to have an understanding of who the populations are that frequently appear in your court. Do your homework and learn about them. If you don't know who's in your community, there are a number of ways that you can find that out. Talk to other colleagues, talk to your court staff, go out in the community, look at what are the community groups that meet, that address particular populations. Go to their meetings, ask them for information, ask them for help in understanding the needs of their particular population. I think there are as many ways to do this as you can think of to get information. And then ask yourself this question: what population do you enjoy or feel having in front of you, or feel like you really have some sort of special rapport with, either because you have family members that fit in that population, or that's your fill in the blank ethnic, religious, language background that makes you feel like you have a special rapport with them. What is it about that population that makes you feel like I can really do a good job with this group? And then look at that, what you do with that population, and say, all right, why don't I use the same techniques, the same tactics with everybody else who appears in front of me? And then make sure that you have a good understanding of the resources available. So interpretive resources, or legal aid for different populations, or different kinds of programming that are tied into or tuned into a particular population. So this is all about understanding what's available in your community so that you can do two things. One, educate yourself about it so that when members of that population are in front of you, you understand where they're coming from. But also it means that you can educate them about services available to them, maybe groups or agencies that they weren't aware of, which obviously benefits them, but also gets the message to them that you heard what they had to say, that you understand what they need, and you are taking some steps where appropriate to try and link them with the services that they need in the community. So to address some good practices, some things I think you should think about doing, obviously speaking slowly and clearly. We all have buttons that get pushed in court. So again, this is a two-step process. Understand what your buttons are. What triggers a reaction from you, even if it's not a verbal outburst, a nonverbal outburst or a nonverbal reaction can be just as difficult to overcome. So what is it? Be prepared for those triggers, and so when they happen, you don't have the same reaction, that you are able to maintain that same calm demeanor, the same demeanor that you want to send out, saying, listen, I'm here, I'm going to understand, try and understand what you're asking me. I may not do what you want me to do. I may not give you the response or the sentence that you want, or the decision that you want, but my decision is going to be fair, and I am going to explain how I got to that decision and how it should apply to you. Don't assume that everybody has the same experiences coming into court that you do. I think it's a good idea to have someone come to your court, someone whose opinion you trust, and have them sit in the courtroom, someone preferably who's not a lawyer, who can just sit and watch you for a day, so that, and the point here is that they become sort of the woodwork. You're not tuned into that person, that friend, that acquaintance. They're just there. And after a while, you'll forget they're there, and you will conduct yourself as you always do. And then talk to them about their observations, their experience in watching you conduct yourself in court. What you're really trying to do here, I think at the end of the day, is to match your intentions, because we all, as judges, we all want to do a good job. We all assume that we're going to be unbiased and impartial. We all believe that we're doing that. So what this is about is matching your intentions with the defendant's experiences. And those are not always the same. And so I think this is a good way to check and see what you're doing. Repeating yourself again and again is maybe frustrating, but sometimes it's what you need to do, and you need to do it in a way that each time you repeat yourself, it's just as clear, just as non-threatening, non-paternal as the first time you said it.